Great. So thank you everyone for joining today. Obviously, we will be going over MoCRA. And MoCRA is the most significant expansion to regulate cosmetic products since 1938. This new requirement will help ensure the safety of cosmetic products that are being used by consumers every day. Just a bit of history. There was the Voluntary Cosmetic Registration Program. You'll also see it use the acronym VCRP, which was started in 1972. And this was a paper-based mail-in submission to FDA. FDA has stopped accepting and processing both electronic and paper submissions of the Voluntary Registration Program for cosmetic establishments and products on March 27, 2023. FDA is now developing this program for the submission of facility registrations and product listings mandated by MoCRA, and will provide further updates on its availability. The prior VCRP submissions will not be transferred to this new portal for MoCRA, so please keep that in mind. And I will pass it over to Shelly.
Thanks, Caitlin. So good to talk with you all this afternoon. We really appreciate you joining. So I just wanted to touch on the definition of cosmetics and the products that are covered under this new regulation. At our firm, we've received some questions about whether certain products are covered under the regulatory framework, including pet grooming products. So I'd just like to clarify, most of you know, FDA defines cosmetics by their intended use. And you see these definitions here: preparations of cosmetic ingredients with a qualitatively and quantitatively set composition for use in a finished product. And here the intended use statement: articles intended to be rubbed, poured, sprinkled, or sprayed on, introduced into, or otherwise applied to the human body for cleansing, beautifying, promoting attractiveness, or altering the appearance. So this does not apply to pet grooming products, over-the-counter drug products that may have cosmetic ingredients as inactives. Are from an ingredient declaration perspective, still regulated under the cosmetic framework, but for all intents and purposes, this is for cosmetics and personal care products, which include, makeup, skincare, deodorants, shaving creams, and perfumes. So just to give us an idea of the kinds of products we're talking about that have coverage under MoCRA.
And during today's webinar, we will go over the FDA's draft guidance for the registration and listing of cosmetic facilities and products. We're specifically going to highlight the definitions of all this lingo that you may or may not be familiar with, who's responsible, what information is required, and how to submit and when. I do want to reiterate that this information is based on the draft guidance from FDA. They have not yet released the final guidance to industry, but we are expecting that will be released any day now, and we'll have more information then.
So we'll jump into specifics about who is covered under MoCRA. And you probably have heard this term and new buzzword, in reviewing the regulation. But FDA is using this term called responsible person. And this relates to a manufacturer, packer, or distributor of a cosmetic product. But the key is that that entity is listed and their name appears on the cosmetic product label itself. There are small business exemptions, which are defined by average gross sales in the U.S. for the preceding 3 years, being less than 1 million, and also for companies who don't engage in processing or manufacturing of certain items, which I know it's on a later slide, but just to give us kind of general framework for what we're talking about here. Exemptions include companies that are producing products that regularly come into contact with the mucous membrane of the eye under conditions of use that are customary or usual, cosmetic products that are injected, cosmetic products that are intended for internal use, and cosmetic products that are intended to alter the appearance for more than 24 hours. So small businesses minus these exceptions are exempt from facility registration and product listing. So I'm sure, as Caitlin will talk further, we do encourage companies now to understand their operations, current labeling responsibilities outlined by private agreements, and the relationship between the supply chain parties in terms of who is on the label itself or who wishes to be on the label. And then also looking at your operations to see if there are any exemptions that you could take advantage of. Even though there may be a regulatory exemption, you may also want to consider whether customers and purchasers do require compliance and require this registration and listing. But just as a place to start in evaluating your registration obligations under MoCRA.
Great, so I'm going to go over the cosmetic registration notice. A pilot program for the cosmetic facility registrations and product listing submissions was created to test the various forms of submission of this content. August of this year was the pilot program deadline, and they had 9 participants in this. The testing of this program began on September 15th, and it will conclude at the end of this week. Cosmetic Direct is FDA's electronic submission portal where users can manually populate a web form or upload the converted SPL file to the system to go to FDA. The testing phase has also reviewed the submission of the paper forms, but as I'm sure we'll state several times throughout this webinar, FDA has stated that in their draft guidance that they highly encourage the use of electronic submissions. Great, so I'm going to go over the requirements and exemptions, which Shelly did briefly touch upon. So really, who has to comply with this? And to put it simply, any facility that is manufacturing or processing a cosmetic product that will be sold in the United States will need to comply. As a manufacturer, packager, or distributor of a cosmetic product, if your company name is identified on the product label, you must comply. Now, like Shelly had mentioned, there are exemptions. Specifically, small businesses are excluded. So if a company is averaging the gross annual sales income for your cosmetic products in the past 3 years, and that's less than 1 million, and your company is not involved in the manufacturing of the product, you would not have to comply. There are also certain types of products that are excluded, which we touched upon. So anything that would come in contact in the with the mucous membrane of your eye, anything injected or intended for internal use, or even products that are intended to alter your appearance for more than 24 hours, those would not fall under this requirement and would not need to comply. Now, to specify the types of facilities that are excluded from this regulation, specifically would be any sort of retail locations such as beauty shops or salons, cosmetic product retailers, pharmacies, hospitals, doctors' offices, and any public health agency. They are not considered facilities that are manufacturing product, so they would not need to comply. Other entities that would be excluded from submitting a cosmetic facility registration would include a trade show or any other venue where you could possibly be providing cosmetic product samples. So if you're going to a trade show anytime soon and you plan to give out samples of your product, do not worry, that trade show does not need to be a registered facility. And if a facility is manufacturing a cosmetic product solely for research purposes and is not being distributed to consumers, they would not have to comply with the facility registration. When you're reviewing your product portfolio, you may be overwhelmed by the number of cosmetic products your organization may have. I do want to say to keep in mind, if a product comes in multiple shades, flavors, scents, or even has multiple packaging sizes, they can all be contained in one product listing as long as they all include the same formulation. All product listings will also be assigned a product listing number. And if you're familiar with the drug listing process, this would be comparable to an NDC number.
And Caitlin, before we get into this next section, because we've been getting these questions as well, if there's a question as to whether your operations are subject to MoCRA or whether there is an exemption that could apply, we recommend that you either internally review your operations and have a letter to file documenting your exemption if there is kind of a gray area or question mark, or if you squarely fall into the requirement that you must register and list, that you do so. But if there's just any kind of gray area about your compliance obligations in terms of registration, having a letter to file just to make sure you kind of documented your diligence. If there were ever to be an FDA question or an inspection, anything of that kind is always advisable.